Resuming debate. Order, please. Order, please. This is a difficult debate where there are strong disagreements. I would ask for respect on all sides of the House, and I will tolerate nothing else. The Honourable Member for Vancouver Centre.
Thank you very much, Madam Speaker. I rise to speak against Motion 312. Now, Madam Speaker, Motion 312 calls for the creation of a special committee that would evaluate subsection 2231 of the Criminal Code, which currently states, and I quote, that a child becomes a human being within the meaning of this act when it has completely proceeded in a living state from the body of its mother, close quote. So this motion asks for a special committee of parliamentarians to review the legal definition of personhood in Canada. The definition of fetal personhood and related Supreme Court jurisprudence is closely linked to the legal status of abortion. So the Liberal Party does not support any legislative action that would reopen the debate on abortion or might criminalize abortion. And if passed, Motion 312 can reverse the hard-earned rights of women by restricting their access to safe and legal abortions. The Liberal Party will oppose this motion. During the 2011 election campaign, the Prime Minister promised that his party would not change the laws on abortion. And I quote, "As long as I am Prime Minister, we will not reopen the debate on abortion. We will leave the law as it stands," and I close quote. Now, Madam Speaker, the Conservative Party has a troubling history on the issue of election promises. You recall in 2004 when the Leader of the Opposition, now the Prime Minister, noted that the death penalty and abortion are not issues for the first Conservative government. Yet, in November 2007, halfway through the Conservative Party's first term in government, he broke that promise when his party refused to seek clemency for Ronald Allen Smith, a Canadian on death row in the United States. By refusing to seek clemency for Mr. Smith, the Conservative Party reversed the long-standing practice of seeking clemency for Canadians on death row abroad. And the Prime Minister and the government was also in contravention of the United Nations Convention to abolish the death penalty, of which Canada is a signatory. Now, Madam Speaker, with motion M312, the party is now reversing the Prime Minister's promise not to reopen the debate on abortion and to leave the law as it stands. It is clear that this government cannot obviously be trusted to keep its word on any questions of fundamental justice. By allowing this motion to stand, the Prime Minister can tell Canadians that the neutral stance of this motion on legal personhood does not open up the issue of abortion, that it is merely asking for a clarification on the definition of personhood and whether the law as defined in section 2231 is outdated. Madam Speaker, this is shameful. And this government is being disingenuous, and so is the Prime Minister, obviously thinking that Canadians are simpletons. The discrepancy between the opinions of the member for Kitchener Centre and what he said in this House today and the neutral stance of his motion should be noted by this House. Today, on April the 26th in the Ottawa Metro, the member for Kitchener Centre, and I quote, said this: "This motion opens up the abortion question. If we reach a conclusion on when a child becomes a human being, then all of the other issues about abortion can be discussed with that as a bedrock foundation." So we are being disingenuous in the House when the Honourable Member stands up and makes a speech and says that this is being honest and that this is about a neutral motion. It is not being honest, and it is not about a neutral motion. And that is a cause for concern for those of us in the House, Madam Speaker, because if the intention of the member for Kitchener Centre had been honest, he had choices. He says that subsection 2231 is outdated. Well, he did have a choice to directly amend the Criminal Code and propose a bill to do so if he believed that the Criminal Code was outdated. But he did not do that. The member said that section 2231 is unjust because the definition of personhood on that section does not include the fetus. Well, if he believed that the section was unjust, then he could have brought forward a bill to redefine personhood directly. And the Prime Minister should not have given this member the back door and waste the time of the House to use M312 as a backdoor to recriminalise abortion. But again, Madam Speaker, the history of this Prime Minister and this government is to always use the back door for contentious issues. One can recall the private member's bill of the member from Portage Liska on gun registry, which the Prime Minister had said he would not deal with. And there we had a private member. Then we had the private member's bill by Ken Epp, who is no longer in this House, about the unborn victims of crime, which was about abortion again. And we see this backdoor trial balloon in which contentious issues are floated forward to see what the public would say. And if it became too hot to handle, then it would be withdrawn or it would be voted against by the government. And we're seeing this same kind of dishonest behavior, this ingenuous behavior in this House. Now we see that the committee will be asked to look at medical evidence of fetal personhood. In fact, medical evidence speaks to the viability of the fetus, how the fetus and how long the fetus can exist outside the maternal environment. And that is defined very clearly. You don't need a committee to see it, that viability of the fetus, how long it can live outside of the maternal environment, what are the times, what are the ages, etc., etc. It's all very clear, internationally and nationally. And then it means that if that fetus is viable and the fetus is born before viability, it will only exist with a great deal of technology to help it to do so. What is surreptitious about this bill is that the medical definition of fetal viability does not define personhood. Nowhere does it and nowhere can it, because the Supreme Court is very clear when it ruled unanimously in the case of Tremble versus Daigle. And I quote, "The task of properly classifying a fetus in law and in science are different pursuits. Ascribing personhood to a fetus in law is a fundamentally normative task. It results in the recognition of rights and duties, a matter which falls outside the concerns of scientific classification." This is echoed again in the 1999 Supreme Court decision, Dobson, Litigation Guardian of versus Dobson, in which Justice Corey, writing for the majority, asserted that the Supreme Court could not impose a duty of care upon a pregnant woman towards her fetus or subsequently born child. To do so would result in very extensive and unacceptable intrusions into the bodily integrity, privacy, and autonomy rights of women. And Madam Speaker, I want to draw for you here a couple of scenarios. Let us imagine that this committee is formed. Let us imagine that this committee redefines personhood as it is now said and goes against all of the Supreme Court rulings to date. What is going to happen, Madam Speaker? At the age of medical fetal viability, which we now know is very clearly stated at 20 weeks, after 20 weeks, is the government and the state going to put a woman in jail if she does not wish to maintain that pregnancy within her person? Are they going to put her in jail and force her to keep this child until term? That outcome is not only ludicrous, it goes against every single human right that we can think of, Madam Speaker. I mean, it's shades of Margaret Atwood's Handmaid's Tale all over again. This is an absolutely unacceptable thing to even imagine. So that is what is going to be proposed. Are you going to force a woman because the child has to be carried and is in the woman's body until it comes out of the woman's body? It is totally dependent on the maternal body to keep it alive. So are we going to do this? Are we going to lock women up and force them to carry a child to term? Because the Constitution speaks very clearly of the woman and the security of her person. The Constitution and Charter, Madam Speaker, is the umbrella under which all laws are written and interpreted in this country. And the Supreme Court declared in 1998 the entirety of the country's abortion law to be unconstitutional, noting that, quote, "Forcing a woman by threat of criminal sanction to carry a fetus to term unless she meets certain criteria unrelated to her own priorities and aspirations. The law asserts that the woman's capacity to reproduce is to be subject not to her own control but to that of the state, were essentially, therefore, a breach of the woman's rights to security of the person." We have seen over and over, Madam Speaker, that the Supreme Court has shown that the security of the person is tantamount and is above every other piece of law. and because, as it is said, that the law, the woman's capacity to reproduce cannot be subject to anyone's control but her own, is a breach of the woman's right to security of the person. So that kind of idea of Margaret Atwood's Handmaid's Tale would be obviously absolutely ludicrous right now. But we want to look at the issue of, does this government believe that it can then tell physicians what they can or cannot do? And Madam Speaker, I can tell you this own government has said recently on the issue of CCSVI that the government should not be dictating guidelines to the medical profession. So then what is the use of this debate in the first place? If nothing that comes out of debate is going to be able to be anything but unconstitutional. You know, today we see the committee budgets are cut by 30%, and yet we want to waste the government's time, everyone's time, and we create a committee to do something that is, in the end of the day, Madam Speaker, totally untenable and unconstitutional.
Resume.